have everybody here. I'll begin with some housekeeping. This is a Board of Equalization BOE hearing, which is an appeal to a decision made by the commissioners. The appeal was received 4/29. Looks like it's a proper application after much communication between the legal counsels of each of the proper format to appeal. Last meeting we had, which wasn't a hearing, was to deny the appeal because it wasn't under the applicable statute for appeal. Apparently the two attorneys had the information behind that. We do have, or without objection, want to make the application part of the record from the prior hearing. The application was filed it was received by us on December 23rd. So we'll make that part of the record for this, which will avoid us having to go through all the technical qualifications that were spelled out in the application, since we do have limited time. Board of Equalization hearings generally, and we hold a lot of them for appeals of property values. Those are generally done. They allow 15 to 20 minutes. A Board of Equalization generally takes into account the assessor's information at that time, where this is a commissioner's decision. It's a little different. Board of Equalizations are limited to the hearing is held on the status of the property tax by statute is January 1st of the year. Anything beyond that, this will be a little different because the applications can be made anytime during the year. So it wouldn't be considered, the information, the decisions are discretionary, and on the Board of Equalization hearings on property values set by statute, that's usually the date that defines when the decision information is permitted. Today, we made this decision on the application filed by BiologiQ, so we'll consider that to be, the date that's applicable for that. What we'll do is we'll go through the appeal articles. There is an opportunity in other Board of Equalization hearings to add any new relevant information, statistical, factual, things that might apply to the decision, to make sure that we make our decision based on pertinent data and that.
Mr. Chairman? Mr. Chairman, this is Dave Radford. When you say we make our decision, I need to let you and my fellow Commissioner Brian Reed know, and then anybody else that's here. I think Weston and Scott are probably listening, but I received an email from Weston Davis last night that strongly encouraged me to recuse myself. So just making you aware that I've received legal counsel to do so. This will be my second recusal in 18 years, so it's very difficult for me. But I'm going to take legal counsel's advice, because I have not sought outside legal counsel except on one other matter.
The recusal is based on, maybe let Weston address that.
Okay. Yeah. Are you aware of it? I wasn't sure that you were aware of it. Did you? Have you talked to Weston about this, Roger?
I was aware of the issue, but we didn't receive any communication that you received. I'll just let Weston deal with it.
Two questions. One's a separate preliminary matter we need to address, Commissioner, and that is the attendance of the assessor. And I also want to make sure that we're giving the applicant as much time as possible. The question has come up whether or not a campaign contribution from, I believe, Mr. LaPray, who's the owner of BiologiQ, to Mr. Radford's campaign makes it such that he is potentially perceived as being biased in any decision that he may make. It's my understanding the contribution was made after a decision and wasn't related, but where we have a pending campaign contribution on a matter where Commissioner Radford would be sitting as a quasi-judicial officer, it does create some concerns about potential bias and other violations of law. And so I've politely asked Commissioner Radford to recuse himself so that there's no even appearance of impropriety. So that's that issue. Dave, I think that's what you're asking me to talk about, and that's essentially what my concerns are.
Okay. Well, I appreciate, where you're coming from on that, having where your dad has served as state legislator. My problem is that if Frank Vandersloot gave me $1,000, or if my opponent was received $1,000 from, say, Mark Fuller or a couple of his friends, would that require me a recusal on, various issues? But I guess my point is, I'm going to take your legal counsel and your polite advice, because I don't want to hurt BiologiQ's application if that's what may be in jeopardy here. I think the record's clear that I was.
Okay, Dave, don't discuss it once you're accused yourself.
Yeah, Mr. Chairman, you can shut me down anytime you want, but I'm just
well, if you're accusing
myself, and that's fine. So I'll go off of this call right now, but I'm doing it not happily. I'm just telling you, I'm not. I've got 7 months left in this term, and I thought one recusal is enough, but it appears that I'll have two in the whole time that I've served. Anyway, thanks, Mr. Chair. Thanks.
We would just state for the record that we see no reason for a recusal, but we'll respect the choice made by the member of the Board of Equalization.
Thank you. Okay, the other issue you wanted addressed was the issue of the assessor being present, the assessors having some significant back problems where this isn't dealing with a value. We'll let him review this if necessary.
I guess the question I have, Commissioner, is whether or not Mr. Fuller and Mr. LaPray are willing to allow the assessor to or waive his or her presence. Usually the presence of the assessor is to defend values, not equalization. So I don't know that his presence is going to be much of anything other than fulfilling a statutory requirement. So I just want to make sure on the record that there isn't a question whether or not the board is properly convened.
This was brought to my attention before this hearing. I do agree that the statute mandates his invitation and participation if he wishes. I agree that this matter does not expressly address an assessment, but the statute doesn't allow the matter to proceed in his absence unless there's some waiver. I have no objection. My client, do you have any objection to proceeding in the absence of the assessor?
Okay. He was muted, but apparently said no.
Okay, then I have no objection to proceeding. I agree that this is not an assessment which would normally involve the assessor, and so I think we can proceed.
Yeah, I have no objection, Mark.
Okay.
Thank you.
Okay, so with that, we'll go ahead, and that's the explanation of BOEs. At the end of the BOE, we'll either take the issue under advisement, as we do typically, and issue a written finding or make an oral finding today, depending on what issues and whether we feel comfortable enough with those. So go ahead, Mark, and present the items outlined in your appeal and any other things you feel like you need to add.
Thank you very much, Mr. Commissioner. It's about 11 minutes after 1, and I think I'll take about 10 minutes, so we should be able to be finished in time. As you're aware, this is an appeal of BiologiQ from the Board of Commissioners oral determination on February 26 regarding our application for a tax exemption. At the time of the hearing, there was no dispute that BiologiQ's property and project complied with all of the requirements of Idaho Code Section 63602 NN. BiologiQ proposes to improve identified property by the placement of a new building and a new manufacturing plant in excess of the $3 million minimum amount set by county ordinance. The project period involved is to extend for 5 years and involves a defined project on a specific parcel and includes qualified investment. At no point during the previous hearing was there any contest to BiologiQ's compliance with each of the 5 conditions of 63602 NN. The commission denied BiologiQ's application based on 2 factors. The commission's factual concern was being unable to hire and retain county employees because of nearly full employment status in Bonneville County on February 26. Obviously, since the filing of BiologiQ's application, there has been a significant change in the economy due to the COVID-19 pandemic, resulting in significant numbers of citizens in Bonneville County becoming unemployed. The county's concern with retaining county employees is significantly minimized and less relevant because of the need for employment and the significant need for business investment in Bonneville County, which has risen drastically in recent months. The second reason for denying BiologiQ's application was based upon actions then being taken by the Idaho State Legislature during the 2020 Idaho legislative session. Now recall, there was no written decision issued, so all I have to go by is the statements made by the commission at the hearing. And one of the commissioners commented on how the commissioners were being portrayed with regard to their stewardship over over property taxes. On February 25, the day prior to the commission's denial, the Idaho House of Representatives passed House Bill 409, which was designed to freeze budgets for taxing districts, including Bonneville County, for the period of a year. On March 12, the Idaho Senate rejected House Bill 409, and the legislature has now concluded its session, and there is no longer any risk of county budget being frozen. The budget freeze, unadopted by the legislature, cannot serve as a legal basis for the denial of BiologiQ's application. These 2 factors were the factual and legal basis for the denial of BiologiQ's application, and significant changes now justify overturning that denial. This Board of Equalization is a separate and distinct body from that of the county commissioners, although both boards are made up of the same individuals. The Board of Equalization is a constitutional body created for the purpose of equalizing values of property subject to taxation. The Supreme Court held as long ago as 1927 that the Board of Equalization's power to reduce valuations are coextensive with its power to increase valuations. This board was the Board of Equalization is specifically created by the Idaho Constitution, and it states that the duty of the Board of Equalization is to equalize the value of taxable property in the county under such rules and regulations of the State Tax Commission as shall be prescribed by law. This board is allowed to consider all applicable laws, including Idaho Code 63602 NN, to assure that the county tax load is equalized throughout the county. Section 63602 NN specifically allows for property to be exempt from taxation, which will allow the tax burden to be spread equally among all county property owned, in order to serve the greater purpose of encouraging long-term construction and plant investment, and to encourage business to locate in Bonneville County. The Board of Commissioners was authorized to grant exemptions for the defined project for up to 5 years. But in this case, BiologiQ now seeks a 50% tax exemption for 5 years, which would include tax years 2020 through 2024. During the hearing before the County Commission, statements were made regarding the benefit of spreading the tax burden fairly among all parcels located within Bonneville County. And concern was expressed by at least one commissioner that new businesses should not be fully exempt from taxation. This Board of Equalization's purpose is to serve exactly that end and to allow the taxation burden for encouraging new development to be spread throughout the county, including the burden of encouraging new development. Just as all parcels within Bonneville County are taxed to pay general expenses of the county, such as road development, infrastructure development, county sheriff, etc., granting an exemption pursuant to 63602 NN allows the burden of attracting new business and investment for the benefit of all county residents to be spread fairly and equally among the parcels throughout the county, so that it is not borne entirely by the new developer. In this case, that would be BiologiQ. In order to serve this specific need for fair tax equalization throughout all county property owners, in 2012, the legislature specifically amended Section 33501A to allow appeals of exemption decisions from the County Commission to the County Board of Equalization. Prior to that date, the Board of Equalization only had authority to consider appeals of assessments. But after 2012, the logic for such an appeal procedure is clearly to allow the burden of new property development and long-term revenue enhancement to be spread throughout all properties within the county. For that reason, this board has the authority to reduce the value of BiologiQ's improvements to be constructed on owned real property, on real property yet to be purchased, and on yet to be purchased plant improvements by granting a 50% exemption for a 5-year period. This board must decide if the long-term benefit of increased employment and increased tax revenue should be borne by BiologiQ alone or be borne equally by all county taxpayers for the next 5 years, thereby encouraging BiologiQ to permanently locate in Bonneville County. We request that you overturn the February 26th denial of BiologiQ's application and approve the application for a 50% exemption over the next 5 years. I know that was the argument that most impressed me at the last county commission hearing. And that was the belief that denying the exemption prevented the tax from being, that there was a reason why the tax had to be spread to all of the taxpayers. That's exactly what this Board of Equalization does, is say it's not proper that the new developer should bear the entire cost of development and thereby enrich the county with long-term benefits of employment and greater tax revenue. It allows it to be spread to all county taxpayers, and we request that you reconsider the determination, grant the appeal, and grant the 50% exemption. And that's all I have. I would stand for questions if there are any.
Okay, I do have a couple of questions and things that we probably want added to the record. I'll start with the last statement you made, because sometimes my memory lasts about one or two statements in. It said it's your opinion that is the proper role that new development be borne by all of the taxpayers instead of the BiologiQ, correct?
That is my opinion, yes.
Okay.
And Supreme Court cases uphold the ability of this Board of Equalization to grant that.
Correct. But that ability is also discretionary on what we consider is proper. So, and I think that's in the first, you included that in cite in your first item on your request, citing 63602 NN, that says the Board of County Commissioners may grant the property tax exemption for a defined project for up to 4 years. I recall in one of our prior meetings, your position was that we were required, if they filled out the application, to grant 100%, which I think we came to a general understanding that it is discretionary.
I would agree that it is, and your point is that before the Board of Commissioners, it was discretionary. you're not now before the Board of Commissioners, you're before the Board of Equalization and making a determination whether the ruling made previously should stand or should be replaced.
That's why I wanted it clarified that it's your opinion that this development cost should be borne by all the taxpayers instead of the BiologiQ. So going back to the COVID thing, do you have any empirical documentation or data? Since similar to a Board of Equalization hearing on property taxes, there's a date that we make the decision on, and it's not continuously reviewed each year depending on the changing of the housing market. It goes back to that date. We made this on the date of the application. Have you got any empirical data to show what's happened since in the economy?
I do not have any. If you're asking, do I have a current unemployment rate for Bonneville County? I do not. The general statement statewide is about 15% is the unemployment, whereas at the time of the hearing, I believe Idaho Falls and Bonneville County's unemployment rate was below 3%. I know we were one of the lowest counties in the state at that time.
Okay, and since then, even since we set this up, things have changed because of the reopening, and I think a lot of those who were temporarily unemployed by the shutdown are back to work. Is that a fair statement?
I don't have empirical information to say one way or the other, Commissioner.
Okay, well, we have our weekly updates, a couple barometers that I was looking at, and one just happened to come up today in our planning and zoning update. We have Steve Sear. I can share this report with you if you want. He usually gives us an idea of building activity, month by month, so we can keep track to try to project for growth. In April of 2019, there were 47 permits. In April of 2020, which is right in the middle of the shutdown, we had 73 building permits. In May, which is a partial month, in May of 2019, there were 90 building permits. And up through May 14th, there were approximately, 36 and 28, about 58 building permits, estimated to be 100 to 120. So that would indicate that the economy is still very active. Also, we have 4 new subdivision plats in the queue during the shutdown. We're trying to get back to where we're handling those. Would you consider that some type of data that shows that our local economy is still perking along pretty well?
I would disagree. I think those numbers that you've just provided indicate that our local economy is significantly decreased in both April and May from the previous year. The numbers for both months were approaching half of the previous year's numbers.
Well, maybe you need to see it, because April 19th was 47. April 2019 was 47. April 2020 was 77, nearly double, not half. March on the projected numbers is up about 20 to 30% from 2019, a year ago.
My response would be that's a single factor in one industry in the community. That would not indicate employment, and lots of building permits. I have lots of clients that go out and get building permits even for a considerable period down the road. The fact that a specific permit was granted in a specific month does not mean people were employed on that job, and they could be delayed a considerable time period.
No, but I do think it's an indicator of the general economy, which it's as fair to look at all indicators as it is just unemployment. So let's see, the other thing, the statement, and I think you were referring to me because I was kind of the swing vote on this, as I made a couple of statements, and Commissioner Reed can talk about some of the things he had indicated were the reason for his motion. I was adding to those and thinking, I'm not sure that House Bill 409 was the only factor. It was a factor showing the sentiment of the legislature at the time to the shifting of property taxes, especially increases on the homeowners. There were several other pieces of legislation also besides that one that just happened to be the topic of the day. And yes, the legislature was cut short because of the coronavirus. I don't know what would have happened, but they do still have an interim committee approved. So I think the end of the chapter of that story is still to be written.
Mr. Chairman,
Yeah.
I'm sorry, I didn't mean to interrupt you, but
I just wanted you to get on the record what your reasoning was, because it was, this reasoning on using that one thing for a legal basis to deny it, I think is a little narrow.
Well, I was a little surprised when the application came in with those two reasons of why we took that action. It is unfortunate. I agree with Mr. Fuller that we didn't have, a better written transcript of what happened during that meeting. But I went back and through my notes, I was the one that actually made the motion that we voted on, and I based it on 3 points. The first point for my motion to deny was that I believed that it would cause a tax shift to the homeowners. The increased expenses of the business expansion would be then borne in a greater degree by the residential homeowners. And we've been learning that shift has been happening. And so I believe that the exemption would cause a tax shift was my first reason. The second one was that the economy was very strong in Bonneville County, and that we were one of the fastest growing counties in the state. And I also brought out in that point that I thought it was unfair for all the businesses that have been developing here without an exemption, that for another one to come in and receive that. Just philosophically, that's something that I thought was important. And then my third reason, and I have written here that I said, frankly, BiologiQ is already located here. It's not like we are drawing a new business. Now, it's true they are considering their expansion, and I appreciate that fact. But I remembered in their presentation, they had reported that there were positive factors why they chose this area. I think one of the largest that they mentioned was Idaho Falls Power because of their large consumption. So those were the 3 reasons that I gave in my motion, and I believe that was the motion that was voted on and passed. I do remember that when Commissioner Christensen replied, he did add those other factors that were mentioned, but that was the motion that we voted on.
Anything else you would like on the record, Mark?
Mr. Christensen, my response, and you're right, we don't have a transcript. I do remember your comment. I can't quote it word for word, but the gist of what I understood was that as you were approaching this, recognizing that you would likely be the swing vote, you were seriously considering favoring the exemption until you listened to the legislature the day before. You specifically commented that statements were made by legislators, which I took to cause offense to you as a county commissioner, that you were being accused of not properly using your authority to moderate tax valuations. Basically, the legislators were blaming commissioners for the increase in tax values. I remember being surprised that issue would affect your decision, but that was, to my recollection, the primary reason that you stated. And I would state that House Bill 409 did not get canceled because of an early release of the legislature because of COVID. It was expressly voted down by the Senate. It wasn't a matter of it just got left on the table. It was a determination made not to impose the freeze. And I understood that your primary reason was the approaching risk of a budget freeze.
Well, and I appreciate your perception of my primary reason. That's why I'm glad for an opportunity to clarify that, because there were many reasons, including when you second a motion. It's agreeing with the things that were put forward in that motion that Commissioner Reed just talked about. They're just reinforced. There are a lot of factors on this type of a deal, and the primary reason is the sensitivity towards the property taxpayer, the homeowner's property taxpayer, and that's a lot what's driving this talk of property tax reform, which will go on. But coming back to another point, this decision was made at a snap, with the date of the application. And by this request, and here's an assumption on my part that you're saying we should have that timeline be fluid, not necessarily on a specific date, to be reviewed and changed anytime during the year, subject to the performance of the economy.
This type of exemption actually allows an annual consideration. It can require a report. It actually, if you grant this exemption, forms a contract between BiologiQ and the county, can require an annual report. And if the county commission determines after a year, for example, either that BiologiQ is not performing its required steps, or that the economy has changed to justify a revocation of the exemption, the board does have that authority on annual reviews during the 5-year time period. So you're not necessarily deciding, okay, for the next 5 years, we're going to grant this. It has to be reviewed each year. So yes, I would agree. It has to continue to be fluid as required by the statute itself.
Yeah.
Which I believe allows consideration of things that have occurred since the last hearing.
And one other point before we open it up for discussion, well, a couple points, but the number 2 in your application, it says the property, you made a statement that the property would be assessed at its 2019 value for the next 5 years. Are you aware that that's probably legally impossible because of the equalization of all properties on the tax rolls to commit that that's going to be assessed at 2019 values for 5 years?
I see your point. The assessed valuation does not modify, but the mill levy can be modified, which could affect the tax itself.
The mill levy could be modified, but the valuation of all properties are evaluated and reassessed by the assessor each year, required by law. And those can change depending on the conditions at the first of the year.
That's correct. And if the exemption is granted, it would grant a 50% reduction in whatever that valuation is.
Okay. It's just that your statement was a little bit different.
I see your point. I see your point.
It was a affirmative statement that it would be at that value.
I would correct that. So it would remain at 50% of that value if that 50% exemption were granted.
Okay. And then also, just to clarify, because at the end of the last meeting, you seemed a little upset that we wouldn't take any testimony. That was noticed as a public meeting, not a public hearing. This is a public hearing. That's why we wouldn't do that. And you asked for a legal opinion, just for an explanation.
Thank you. I did not understand that. Thank you for that clarification.
Okay. Anything else anybody wants?
I have nothing further.
Brian?
I don't. I need some time to consider this a little bit. I still believe that the same reasons that I discussed before are still, they are still weighing on my mind. It is difficult for me to give an exemption to an individual business when there's been so much growth and so many other businesses locating here without it.
You have two options. We can take it under advisement, come up with a proposed written finding, which will be adopted in a public meeting, not a public hearing, because this hearing will be closed at the end of this, or we can make a verbal pronouncement today.
Might I inquire, since this is a public hearing, to see if my client wishes to make a statement before the public portion is closed?
Sure.
Mr. LaPray, would you like to make a statement?
Yes, certainly. I appreciate the opportunity to make a statement here, and I understand Commissioner Reed's concern, but I think it's the responsibility, duty, and opportunity of the Board of Equalization to recognize that from a business standpoint, there are differences in businesses, and for those businesses that do take the opportunity to understand the law, apply for these types of exemptions, and then try to make a significant investment. This isn't a little investment. This is a significant investment. Once you're talking about more than $3 million. And the opportunity for a company to come in and make a significant investment and have that, that tax or a portion of that tax abated and then borne equally by the population rather than one business, actually is a great opportunity to encourage businesses to join the community and help the long-term benefit of the community. There's a difference between the short-term, I guess you can call it pain, versus the long-term benefit. You know, in my life, I've always found that the path that starts hard usually ends easy, and the path that starts easy usually ends hard. And for Idaho to encourage and try to attract significant businesses that have staying power and distributing that tax liability for the initial significant investment amongst the entire group seems to me to be a model that is adopted by many businesses around the country, many states, I'm sorry, not businesses. And it's just it's a great idea. It really is one that I would encourage you to think about and consider. And I completely understand Commissioner Reed's reasoning. But in fact, I think that the same, maybe it's the opposite thinking, is that I think that it's a very good thing to do those things, that it's not a bad thing. It's, okay, am I being kind and compassionate when I give somebody something, or am I being kind and compassionate when I help? It's just a matter of a point of view, right? And so it's, you know, we can have these conversations, discussions, and disagree about what we think is helpful or hurtful for the economy. In my business experience in multiple states with multiple sizes of business, I just would make the argument that it would be very beneficial to share those initial taxes for the long-term benefit of the county and of the state.
And I appreciate that. I remember hearing a lot of that same appeal by you before, along with the fact that this would open the doors for a lot of businesses to come in and do this. You know, and I think that's one of the concerns I, just reading into what Commissioner Reed had on that is, you know, and especially with the argument made here today that this is an existing business looking to expand and basing it on the COVID downturn, which, you know, there may or may not be empirical evidence to show the level of the downturn other than general impressions. Lost my train of thought. That comes with age. But you know, that's the question. Is that the direction we feel like we want to go? And you know, you're talking about, in your opinion, I mean, that's the discretion. And that's what's great about these hearings, is we have a chance to get together and share all of our impressions expressions of opinion, and then we come to a judgment on that. So thank you for that. Brian, what's your pleasure?
Well, first, let me add that very much appreciate Mr. LaPray's comments and the fact that he would choose to locate here in our county. I think there are many benefits to locating here, and a business that he's trying to develop is somewhat unique, which is a great benefit to the area. It's not, it's not something that we see very often, and so it's technology driven, and it carries great benefits, and is set to develop into a global business. So I understand the uniqueness of it. I just have to weigh in my mind. I'm not sure that all of the homeowners agree with the fact that they should bear that burden. And I've had so many contact me this winter with concern about their homeowners tax and the increased value in their homes, that it makes it difficult. And I just don't know if they would agree with the fact that they should bear that burden. I would really like to consider this for a day or two and schedule another meeting when we can then bring our thoughts together, have the discussion, and make sure that we give plenty of thought to this decision.
Okay.
Mr. Commissioner, I was asked for some empirical evidence. Let me just give you one fact. Laid off Idaho workers filed 131,101 initial claims for unemployment benefits during the 8 weeks of the COVID-19 state of emergency. That was 2.2 times the total number of unemployment initial claims filed during all of 2019. So over twice as many as the full 2019 were filed in just that 8-week time period. So it has been a significant increase in unemployment throughout the state.
Does that also show how many of those are back to work now that the shutdown has ended?
I do not have that information, nor do I presume the commissioner has that information.
Yeah. Well, that goes to my statement of trying to make, because that's basically what we did, is we made a snapshot judgment in time based on the date of the application, and to consider it at different points during the year. Yes, you are accurate in your observation that at the end of a year you can review it based on that 1 year. So I think one thing I'm going to be considering is, the precedent that sets by doing it multiple times depending on the change of an economy midstream or interim in sometime during that year. So, but I'll go along with your desire, Brian.
Well, I've got one question. May I ask of Weston, our legal counsel?
Well, since his meeting is the one we're holding up, the next meeting, I'm guessing he'll accept that question.
It depends on whether I know the answer.
I'm sure you will. I understood our role initially, that it was really our discretion. We could go any amount, any percentage of value we could exempt, and we could do it for up to 5 years and any time in between. It could be shorter than 5 years. That was what I understood our options were before. At this point in this Board of Equalization, do we still have those options? Their application was for 50% for 5 years. Do we have the options to grant a lesser?
Well, I believe that you do, but that goes towards a question I wanted to ask Mr. Fuller, which is, on this kind of an appeal, is there a standard of review? I recognize that Idaho Code 63-511 talks about appeals from the Board of Equalization, showing that there's an error in the decision. What I haven't found is a standard of review that applies to the Board of Equalization from the Board of Commissioners. The reason I asked that, Mr. Fuller, is it seemed like you'd mentioned that there were some intonations about how we're bound to prior facts and that this is an appeal. I guess I see it a little bit more open than that, at least until it moves from the Board of Equalization to the State Tax Commission or to the district court, assuming it even goes there. I don't know what the result of the commissioner's decision will be, but I guess I'm wrestling with that issue myself, which is, are they able to take additional evidence here with the Board of Equalization in furtherance of the exercise of their discretion? Does that question make sense, Mr. Fuller?
It does. There are only, I've only been able to locate 3 Supreme Court cases that address the authority and power and procedure of a Board of Equalization. I think the one that's probably most applicable is Golden Rick Lumber Company versus Benewah County. That's 54 Idaho 704. What it says in that case is, he says that what it was designed to do was review the level of appeal. The problem is that back then, all the Board of Equalization could do is address assessments. And what it held is that this court is limited by the nature of the proceeding before it, being an appeal by an individual to equalize his, its, or their assessments and bring them in line with the other assessments in the county. But because other parties are not before the court, it may not change their assessments. In that case, what there was an argument that you couldn't just change the assessment of the appealing party, but you could change the assessment of the other parties to the original litigation that were not part of the appeal. And what the Supreme Court held is we don't have that authority. That before the Board of Equalization, as they meet, they really are considering all the property values throughout the entire county. They're equalizing those values. So while the first proceeding before the county commission was specifically addressed to the exemption of the property owned by BiologiQ, before the Board of Equalization, they must consider not just BiologiQ's property, but the assessed valuations of all properties throughout the county. And if their purpose is to equalize that burden, then they have the authority to both increase and decrease the valuations. And that was in the Overland Company versus Utter case, 44 Idaho at 385. Back to your specific question, I think they have the discretion. I think they have the ability. In order to equalize the property values throughout the county, they can assess whatever valuation they want by way of exemption to the property owned by BiologiQ, which is before it right now. What they can't do is change the assessments of other parcels.
Okay, that's helpful. I ran along a case, I'm trying to find it right now, that essentially addressed the same issue. As you're aware, the Board of Equalizations used to be on a state level, and then the Constitution was amended, I believe, to allow the counties to do that. And so there's a little bit of confusion when we look into some of those older cases, but I think that's consistent with how I read it as well, that it is discretionary, and the Board of Equalization in their equalization authority requires some discretion, which would mean that they are able to take in the additional evidence and arguments that you've presented today, which is a different story when it moves to on appeal, if it moves there. Again, I don't want to presuppose what the commissioners may decide. So, okay.
Can I just present one more? Can I present one more thing here? Just take me just 2 minutes.
Yeah, if you make it a quick 2 minutes.
I'll make it really quick. I want to show you one thing right here. I've just shared my screen with you. I want you to know what I'm fighting for. I'm fighting for Idaho. I want you to know who I'm fighting with, who we're fighting with. So this is an article that appeared in Forbes magazine in their June 2020 edition. A billionaire behind the world's largest toy maker bets on spuds to spur the growth. This is Francis Choi. He owns 25% of BiologiQ. And he is building a factory in China that BiologiQ actually, and I think I've actually shown you in the past a picture of the facility. Where is that one? I don't have it right now. I think, you remember the picture of the facility in China that's being built? Somehow I just had that up, but I've got the wrong file up right now. Right here. What I'm trying to do is keep as much expansion and growth and jobs here in Idaho so that they don't go overseas to China. In order to do that, I need to have a competitive business. And as you can see, this facility in China, which is 300,000 square feet, is going to be able to produce a lot of bioplastic. And in particularly here, they mentioned that to create synergies, that plant in China is a stone's throw away from he's the largest toy manufacturer in the world. Well, his partner in a joint venture is BiologiQ based in Idaho. What I'm trying to do here is make a case where I can build a business that can be competitive globally, represent the world, and represent potatoes for Idaho throughout the world. It's very difficult, and our technology is brand new. I need a little bit of help. I need a little bit of support in order to represent Idaho well, represent potatoes well. That's what we're really asking for. And that's why we ask for the people that are in the area here to help participate. I don't think that there's going to be a significant burden shift to them because we're going to still be paying a lot of taxes. Is there really going to be that much shifted to them? I don't see that. I see that even if we pay half of the taxes, that's going to cover any of the additional services that we're going to be providing that are going to be provided to us anyway. So that would just be my request to this committee, is to look at that, to think about that, and see, let's find opportunities to band together to increase jobs and businesses in Idaho that have global recognition. So anyway, I'll be quiet. And thanks for letting me just state that.
Okay, thank you. I think we're well past our time, so we'll close this hearing to any public comment. I think it's the desire of Commissioner Reed, and I agree to take the issue under advisement. We'll each visit with legal counsel independently with our concerns, have him come up with a proposed findings, or possibly even two proposed findings that we'll present in a public meeting. We'll publish that with the required 48-hour notice. That will be a public meeting, not a public hearing, where we'll get together to consider those proposed findings and come to a conclusion one way or the other. So with that, we stand adjourned. Thank you.
Commissioners, was that PowerPoint, was that presented previously? I wasn't at that meeting, so I just want to make sure if there's any documents that are in the record.
I don't recall seeing the picture of the factory in China or that. The other information, yes, I recall seeing, but that one I think was new to me.
I just want to make sure you have those documents here in your office.
Could you email those to us, Brad?
Certainly, I'll send those right over.
Okay.
Brad, send it to commsec@co.bonneville.id.us.
Okay.
Thank you.
Thank you.
Thank you very much.